If you look at the trend of technology since 1986, just this huge, the way it's become woven into our business and personal lives, the amount of information that is now generated electronically, and the trends that Oren referenced, storage, the way that this information no longer is ephemeral, in the way that a telephone call is, and that it's no longer physical in the way the letter is. The letter, there's just one or maybe two copies of that letter. You put it in the mail, and maybe you keep a copy, but those are the only two copies. In a way, you have to think of the internet as a copying machine, making copies of this communication. And now, increasingly, those copies are held by the third party. And how do we deal with that? ECBA deals with it imperfectly. Oren didn't even go quite into the depths of the complexity and imperfection of this, but if it's in transit, it's fully protected by the Wiretap Act. If it's in storage, waiting to be opened, less than 181 days old, it's protected by the warrant requirement. After 181 days old, it becomes subject to a subpoena. Subpoena, I always say, is Latin for no judge has ever seen this. Subpoenas are not approved by judges. They're issued by prosecutors, sometimes given in blank to the FBI agent to fill out in the course of an investigation. Justice Department maintains that as soon as the email is opened, it becomes unprotected, available with a subpoena. Ninth Circuit has rejected that. Rest of the country, it remains uncertain. So you have this mishmash of rules, and yet it's the same content, and we all treat it as if it were the same, that the email in transit, the email in storage, the email here on my device, even when I'm not connected to a network, the email that you print out, all the same content. And yet, increasingly, it sits in a place where ECBA says it's unprotected and where the courts, but for the Sixth Circuit, have yet failed to grapple with it. Basically, the Supreme Court held in Warshak that ECBA is now unconstitutional to the extent that it allows information held by a third party, content of communications, unconstitutional to the extent that it allows that to be accessed by the government without a court order. So I think while the courts are likely to continue trending in that direction, you have one circuit out of 11 or 12. It could take a very long time for the other courts to catch up. Meanwhile, you've got questions of what are the exceptions? There should be exceptions. There will be exceptions. Who gets reimbursed and how do you deal with that? Are carriers immune for complying? A whole host of other issues that are addressed in the statute, which if you leave it just to the courts, would have to be worked out case by case, creating further uncertainty.